Good morning, sir. You're Brandon Bell,
Yes, ma'am.
and this is cause number 24, DCCR 1008. Mr. Bell was previously in court, entered pleas of true in a motion to revoke deferred probation, pled true to counts 2, 3, 4, 6, 7, 9, and 10. And there was not an agreement on probation for aggravated assault with a deadly weapon. And I've received that updated report. Has everyone had an opportunity to review that report?
I
have, Your Honor, in addition to some medical documentation that Mr. Revoke has provided.
Was that provided to me?
Not.
Okay. I'm sorry.
Probably not.
Okay. What should it have?
Based on the updated report, when it goes into Spindletop and some other stuff, Judge.
I don't know what you're talking about. Yeah, I mean,
These are medical records from Spindletop.
okay.
And there's also medical records of how he lost his leg recently from being run over by a dump truck while working,
Okay.
which I think are factors that need to be addressed.
Probably in addition, Judge, if I may, to the fact that you were called the complainant in the underlying case for which he is on probation. It looked like a stretch to even put him on the probation with his history, but she was very adamant about wanting probation or even non-prosecuting, and she came and testified before you the last time the motion was set so that you could advise them both with respect to the no contact order, which I don't think either one of them were following, but I don't have proof of that, but I know
Okay.
that's been a concern, but I had some difficulty with that portion of the case.
Okay.
And if the court would also remember, she was expecting another child, they are expecting another child. And
Okay.
she's
So what,
also-
go ahead and make argument and then I'll,
She's also controlling the checking account. He's getting settlements and he's providing the money to her for the children. They still have a house together. But he does have a place to stay, Judge, and that is his mom's, which I believe she can't go to. And my argument, Judge, is, if I may, is that he has mental health problems. He's had some problems in reference to possibly smoking marijuana, but I think it's contributed to things that he has gone through in life. As I said, I have some medical in reference to an amputation. Of course, he's lost part of his right leg. That was due to a dump truck backing up over him while he was working. And then you couple that with mental health issues. He was reporting, my understanding was he kind of was talking out of his head, as also reported by his mom. That was also outlined in the updated PSI report. We're asking, Judge, that you continue him on probation. He does have obligations with his significant other in reference to the newborn and making sure that they're taken care of, which he does have the funds that he has to be able to give to her. But if there's some program that he can have that's outpatient to maybe give him some direction. One last time, he was put on probation in April of this year, Judge. We're now in November, but the problems have been going on. But he does need to go back to Spindletop. He does need to say this is what you do or not. I mean, according to the pre-sentence report, he is reporting. It's not like he's not reporting. He's trying to pay or has been paying and trying to do stuff. I think he just needs a little bit of a correction and see whether or not he can do it. And you couple all that, I've had extensive conversations with his wife I've tried to tell her the way it has to be as of yesterday. We've talked over the phone.
We're now entering one of the most delicate parts of this hearing. This is the moment when the court isn't just listening to word sits, analyzing attitude, honesty, and intent. One wrong answer here can shift the entire direction of the case.
In the way that it would have to be in reference to separation until they learned how to possibly get along together. So that's what we're asking for, Your Honor.
Ms. Malvino?
Judge, would the court like to hear evidence with respect to counts 1, 5, and 8, Ms. Lopez?
I mean, I guess it kind of depends on the
Just in the context of what she has to say. maybe.
Yeah, for sure.
I call Ms. Lopez.
Ms. Lopez, if you'll raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? All right, you may proceed.
Ms. Lopez, would you please state your full name for the record?
Rachel Lopez.
And how are you employed?
I am the high medium risk officer at adult probation here in Jefferson County.
And are you the supervising officer for Brandon Julius Bell?
Yes.
And do you see Mr. Bell to your left in the wheelchair? Affirmative, record reflect. Ms. Lopez is identified as the defendant.
The record will so reflect.
As a condition of his probation that was granted by this court back in April of this year, 2025, was he given certain terms and conditions that all probationers are to follow?
Yes.
And specifically, you've had an opportunity to review the motion to revoke that was filed back in July.
Yes.
In account number 1, it alleges that he failed to immediately report to you his or her contact information in violation of condition. Can you explain that to us?
There were multiple instances throughout the time that he was reporting where I would attempt to call the number he had provided at a previous office visit and would not be able to reach him. So then I would have to then search through his associates to find someone else who would answer, who would then say, we'll let him know you called.
Notice how the judge's tone changes here. This is no longer a routine conversation. This is a credibility check. The court is trying to figure out who's being truthful, who's holding back, and who's simply trying to buy time. This is where cases gain momentum, or unravel completely.
And so it's standard in our court orders that they are supposed to keep their contact information updated due to the fact that most of the time I cannot give out certain information to other people due to confidentiality.
So it's obviously very important that you're able to reach him and advise him of the conditions of his probation, etc.
Yes, we need updated phone numbers, addresses, things like that, so that we can specifically talk to the defendant.
And he pled true to additional allegations, including providing some dirty UA specimens being out past curfew. Was he ordered by the court to provide all records and documentations as required by you to you as his officer?
Yes.
And did he do that?
Yes, whenever it applied in regards to like Spindletop, yes, those type things. I haven't had any kind of paperwork in regards to the settlement that Mr. Burbank has referenced, but I also recognize that that may be a recent thing. And so that may not be applicable yet, but otherwise, yes.
So some things you're able to verify, but yet others you are not, which is why you felt it important to include the motion.
Correct.
And additionally, in allegation number 8, did he admit to you the adulteration of his UA analysis on or about June 30th of 2025?
Yes, when he submitted that urine analysis that date, it was clear in the cup, and I did make a note of that in my chrono. It should be noted that even if someone is extremely hydrated, their urine is not crystal clear. And so when I specifically asked him in the offices at that date, did you do something to make it be negative? He said yes. And so while the drug test reflects negative, he admitted in the office visit that he had taken something, drank something to adulterate his urine.
And in fact, you and I have had a lengthy conversation in the past about his use or suspected use of K2 synthetic marijuana, which lends to possible negative UAs when in fact he would be positive just due to the nature of that synthetic.
Yes, Ms. Strother, our UA tech, has explained to me that K2 is a difficult drug to drug test for because much like the flu, there are multiple strands of K2 drugs out there, and our drug test can only specifically test for one type.
Now, the tension spikes. We've reached the point where consequences come into focus. The court has two paths: give another chance, or move straight toward punishment. And right here is where that choice starts to take shape. Let's see which direction this is headed.
And so if he had not used that specific type, it would test negative. And so the incident reports that I received through Beaumont PD indicated that the effects that they were seeing in their reports indicated synthetic marijuana use.
And that information is also reflected in your update to the court, correct?
Correct.
With respect to how his behavior appeared to be altered, involving odd hours, showing up at odd places, attempting to contact the complainant, etc., regardless of whether or not they mutually agreed to do so.